Just weeks ahead of a Jacksonville man's scheduled execution, questions about the reliability of key witnesses surfaced in court. Here to tell us about it and how we got here and what might happen next is Nichole Manna. She is the senior investigative reporter at the Tributary. Good morning, Nichole.
Hi.
Nice to have you here.
Thank you for having me.
Yeah. So this is the case of Michael Bell, who is on death row and has been there for decades since he was convicted in a 1993 murder. Can you sort of start by just telling us the outlines of the case, what he was accused of, what he was convicted of?
Right. So he was convicted of killing two people, a married couple, in what's described as this kind of mistaken identity revenge. His brother was killed, and he wanted revenge on his brother's killer. Thought that was who was in this vehicle that he opened fire on. He didn't realize that the car had been sold, so the person he was targeting was not in the vehicle. So he was accused and convicted of killing the two people who were in the vehicle and then spraying bullets into a crowd.
And so this happened at a kind of a package store called Moncrief Liquors. And as you say, he kind of shot into the wrong car. He killed Jimmie West and Tamecka Smith in this case of mistaken identity. And so he's been on death row since 1995 for this 1993 case. What happened recently? What changed and what developed in this case and why?
So recently, I believe on June 13th, Governor Ron DeSantis signed a death warrant, meaning that that Bell's execution would be scheduled and he could start those proceedings. So his execution is scheduled for July 17th. His attorney, Mr. Norgard, filed for a motion for post-conviction relief, saying that two of the witnesses in the original trial have actually recanted their statements and said that they were coerced and threatened and given that information and that they actually did not see what they testified to.
Okay, and so they are saying that they provided false testimony in this case, and there's some understanding that their desire to express that was prompted by the signing of this death warrant, that their kind of realization that Michael Bell is now on the kind of edge of being killed was what motivated them. Is that right?
Yes. So they were actually approached by, we have in Florida what's called the Capital Habeas Unit, which does post-conviction relief and investigation. And they were contacted by a team for a different death row inmate who are doing their own investigations. Apparently had said that they, made these claims that they had lied and provided false testimony. When the death warrant was signed, those attorneys contacted Michael Bell's attorneys to say, hey, you might want to go back and talk to these people. So those conversations happened literally within days of the death warrant being signed.
And the timing is key, of course, because, these things are in motion and everything has to be made in sort of a double step timing. So this motion for post-conviction relief was filed. These two gentlemen who were saying that they lied under oath at the original trial and at some post-conviction, matters after that, signed these affidavits a couple weeks ago. So tell us a little bit about what those say.
Right. So the affidavits, both of them just high level, said that we did not tell the truth and we were coerced. We were threatened by either the prosecutor, George Batey, or the detective from JSO, William Bellina. One of the men said that he was an informant for Bellina. He would get furloughs from the jail in exchange for information, meaning that Bellina would pick him up from the jail during his sentences, take him home, and then pick him back up and bring him back to jail. The other man said that he was again fed information and threatened into testifying.
And these two folks, we should say that the detective, Bellina, has since died. So
yes.
He's no longer alive. The prosecutor in question, who is a very prominent death penalty, attorney here for the prosecutor's office for a number of years, is still around, George Batey, and you have talked to him.
He declined to comment for this story.
Okay. Yeah. So the two gentlemen, Henry Edwards, spoke in court last week. Charles Jones, they both testified, and despite what those affidavits said that they signed, saying we lied under oath, we were pressured by prosecutors and police to not tell the truth in that case against Michael Bell, they came into court and they reversed themselves essentially.
Yes. So before the hearing started, Michael Bell's attorneys made a motion asking for the judge to essentially give them immunity from any perjury charges. Technically, under the law, if they were to say that they did lie during the 95 trial, technically they've committed perjury. So he wanted to make sure that they were protected from potential charges and felt like they could tell their full stories. The judge declined that motion. The state said that they had not reached out to those men in this time frame in this last week. So actually, before they went up to testify, they were given defense attorneys. So they went for about 5 to 10 minutes to talk to their attorneys and came back. And when it came time to testify, Mr. Jones pled the fifth for every question, and Mr. Edwards pled the fifth for most of his questioning.
And so the prosecutors didn't directly reach out to these two gentlemen before they appeared in court, but they did notify the judge that there was a possibility that, perjury charges could arise, and, asked the judge if the judge maybe wanted to have a couple of attorneys on standby to represent these men or to at least counsel these men before they testified in the event that, they might be committing perjury. Is that right?
Yeah, it's kind of hard to say exactly, did the state approach the judge? Like what happened in those, conversations before the hearing? I know the judge said multiple times, this is my decision. I am making this decision to give them attorneys. So, who's to say what the conversations were before then?
Okay. And as you noted, had Henry Edwards recanted. He had originally said he'd kind of seen this. Now he says he didn't see anything, at least in his affidavit. He said he didn't see anything. And at the hearing, he has this kind of really unusual statement that he made where he said that when he met with the investigators for Michael Bell, that he thought that the attorneys were actually authors putting together a movie script. Let's take a listen to what the attorney's reaction was after Henry Edwards said that.
Are you kidding me, sir? I mean, seriously, you really thought two investigators representing somebody in a death warrant were making a movie?
That's what I thought.
Okay.
So obviously the attorney there for Michael Bell expressing just kind of utter disbelief that would have been a misunderstanding. But we should say that, the judge ultimately found the two men more credible than the investigator who had presented the affidavits and said that these men testified to this.
Yes, and I think that there were multiple reasons for that. I think one, it came out in the hearing that the investigator was the one who hand wrote the affidavits. He said he was the one that wrote them, but then he went through paragraph by paragraph with each man, had them initial the paragraph, and then went through the entire document, had them sign. So I think that was a point that the judge really looked at. I think the other thing was that there were no recordings of the interviews, and the investigator, gave his reasons for not recording.
What would those have been? I mean, it does seem like if you're going to kind of have this essential testimony from people recanting their key testimony in a capital case, that perhaps you would want to make a recording of that.
Yeah, I had the same question. And he said that they, they're not police, they're not attorneys, they're just investigators. They want to make sure that people understand that they're not the cops. And their argument is that people might feel uncomfortable if there's a recording device out. They might not feel like they can talk as freely. But I think the state found that argument pretty ridiculous and kind of like drove home the question of like, why did you not record these?
Okay. And so the judge essentially, as you said, refused to grant immunity to these two, and they essentially either changed their testimony or in the case of one of them, simply refused to answer
Right.
questions, claiming his Fifth Amendment right to not incriminate himself. But they weren't the only two that were called to testify. There were 4 other people from the original trial that were called, and they all said essentially a version of what those men said, or what the men said in their affidavit, which was Detective Bolina and Prosecutor Bate, one or the other or both, coerced us or threatened us or leaned on us in some fashion about our testimony.
Yeah, correct. There was one woman who said that she was threatened by having her kids taken away. She did preface that by saying if she did not testify truthfully, and I think her using that term truthfully is also another point that the judge, really listened to as far as her credibility. Like she claimed that she was threatened but then, added, like, if I didn't give a truthful testimony. There was another woman who actually confirmed a point of the affidavit for Mr. Edwards. He said in the affidavit, and he pled the fifth when asked about this, if he was an informant for Bellina and if he got rewarded for being an informant. She got on the stand and confirmed both of those points and said that Bellina would actually, when this man was in jail, remove him from jail, give him plain clothes, bring him home for a day, and then pick him up and bring him back to jail as reward for his testimony. And then there was another woman who said that she was brought down to the jail for 12 to 14 hours and was screamed at the entire time by two detectives. Those detectives weren't named, so I don't know if Bellina was one of them. There was another woman, Michael Bell's aunt, who said when Bellina and Bate got to her house, Bellina was standing over her the entire time, yelling at her. So they did confirm some of the stuff that was in the two men's affidavits.
And is it possible, or is there a sense that perhaps, just there were different norms at the time it sounded like the judge said that, especially if they were kind of pressuring people to testify truthfully, as opposed to testifying them to lie, as the two gentlemen had been saying, that was somewhat different. That there's all kinds of reasons that a prosecutor or a detective might need to sort of remind people of the importance of testifying, of showing up when they've been asked to testify, that these people might have been reluctant witnesses because they were all close to Michael Bell, and perhaps a little bit of, driving that point home with some kind of pressure would be, allowable.
Yeah, that's exactly kind of the sense that I got. Was it just seemed very normalized of just that's how things were done. Like, that's how you closed a case. That's how you got an arrest and you got justice. So I picked up on that same sense. And then the state only called one witness during this hearing, who was actually George Bate. And they asked him, did you threaten anybody? And he said no. So I think that weighed heavily on the judge as well, that you have this former prosecutor who says, no, I didn't threaten anybody. This isn't true.
And so that's important. So he was in court for these
He's in
proceedings.
Scotland, so he was called in via Zoom.
Okay, and so both sides, though, got to question him
Yes.
about his conduct, and he basically said that just didn't happen?
Yes, and then when the state questioned him, he said that didn't happen. He said that he actually didn't talk to the aunt until the grand jury was called.
The aunt being?
Michael Bell's aunt, Paula Goines. She is the one who said that Bate and Bellina went to her home and that Bellina stood over her and was yelling at her. And Bate testified that he actually didn't meet her until the grand jury, specifically because he knew this is Michael Bell's aunt. They're very close. Like, I just want to question her in this capacity with her attorney there.
So his memory of that was good, and he said it didn't happen.
Right.
Mm-hmm. If you're just joining us, we're talking to Nichole Manna. She's the senior investigative reporter at the Tributary. We're talking about her recent reporting on a pending death penalty case. And if you've got questions or want to join the conversation, give us a call at 904-549-2937 or email firstcoastconnect@wjct.org. You can, of course, reach out on social media as well, Facebook, Instagram, or X at FCC On Air. So the judge, in his order, which basically came out the next day after this evidentiary hearing, said, that he did not find the reversal, the affidavits that they had signed saying that their testimony was false. He didn't find that credible. In the case of the one guy who claimed the fifth throughout the hearing, he said, well, he didn't even testify to anything, so there's really nothing I can judge about his credibility.
Right.
But he also said that this wasn't really a timely claim, and there is a lot of procedure in a death penalty case, and there's certain limits on, when certain things can be addressed, when new evidence can be taken up. He seemed to think that perhaps some of this should have come out years and years ago during, many layers of post-conviction proceedings about whether he had effective counsel or, other claims that he may have made.
Yes, exactly. When you're filing these claims, they have to be quote unquote timely, meaning they have to have been information that you could not have possibly had before this. It must be new information. And I believe this is the first time I heard it. There's some year timeline. If you get this information, you have a year, to report it.
If you know that there was something that was perhaps new evidence.
Yeah. So I think the question is, why did they not know that these two men wanted to recant years ago? Why were they not questioned? Norgart said,
he's the attorney representing
sorry.
Michael Bell. Yeah.
Yeah,
Bob
he's the
Norgard.
appellate attorney. And he said we had no reason to talk to them again, that their testimony didn't change during a 2002 evidentiary hearing. So they had no reason to go back and talk to them, that they didn't know that they wanted to recant, or that their stories had, changed, and that, they didn't know any of this information until attorneys for another death row inmate contacted them and said, hey, you might want to talk to them.
Okay. And so we should talk a little bit about that because, I mean, as we said, it appears that some of their desire to recant initially may have been prompted by the signing of this death warrant and their realization that the death now is imminent for Michael Bell. But also, the investigators learned about, concerns about the conduct of Detective Bellina and the prosecutor, George Batay, from another case. And that is a case that you also were the first to report on. Remind us about the Hartley case. What is at stake there, and why it is that the conduct of the detective and the prosecutor became paramount in that case?
Yeah, so Kenneth Hartley is somebody who was also arrested for murder in the same neighborhood in 1991. He went to trial in 1993. He was also investigated by Detective Bellina, was also prosecuted by George Batay, and even had the same judge, Judge Olaf, as Michael Bell did. So there were a lot of similarities between those cases as far as, people now wanting to say that they recanted. Kenneth Hartley, there were 3 jailhouse informants who testified at his trial. 2 of them have recanted their testimony in the last 3-4 years. One of them said in his affidavit that he felt threatened by Batay. So again, we're seeing that that string between those 2 cases into testifying that before they went to trial, he changed his mind, said I don't want to do this, and was threatened to continue with his testimony. And so Norgard, the attorney for Michael Bell, mentioned that story in his filing, and also said this is the first time we're seeing that Bellina and Batay had this pattern because of the story that was just published, in March.
And so they're saying we really couldn't have known about this alleged pattern that involved these 2 people that were also involved in our client's case because it was just reported in the reporting that you did.
Exactly.
Okay. And so, I mean, we've had you on to discuss some of the reporting that you've done in the Hartley case. The fact that it's the same people, it does seem to, have some echoes of it. But, these are difficult cases to cover when they're current. I mean, there's a lot of complexity to death penalty cases. It's extra hard when you're looking back at records that are decades old, cases from the early 90s. So what are some of the roadblocks that you've found just as a investigative reporter trying to locate and kind of uncover the truth about what happened?
In Hartley's case,
or in either, but
Bell's.
sure, in Hartley.
Yeah, I just started reporting on Bell's, the last 2 weeks, so I've been having to really catch up and learn a lot, and just reading his past post-conviction filings. The hardest part is a lot of the people, especially in Kenneth Hartley's case, are no longer with us. Detective Bellina has died. Judge Olaf has died. 2 of his informants who testified against him have died. So just because these cases are so old, we're seeing people have died in the meantime, or your memory is not as clear. I think that was an argument that was made in Bell's case that maybe you don't remember what had happened. One of the witnesses in his case is going back to his aunt, even said, I'm having struggles with my health, and, I don't really remember, I don't recall. So I just think it being 30 years comes with a whole new slew of issues.
Yeah. We have a question from Susan on Facebook, and she wants to know how common are false testimonies, essentially the claim at the center of this post-conviction request.
Oh my God, great question. So in the Hartley case, we actually took a look at informants and jailhouse informants and how common they are. And I believe...
and we should just pause and clarify there. I mean, the Hartley case, you may have already said this, but that essentially depended on the testimony of what are sometimes called jailhouse snitches, who are people who often repeatedly, in multiple cases, provide testimony for prosecutors that is sometimes very key to a prosecution.
Yeah, they're often the only witness to a supposed confession. And we've seen that, I believe the Innocence Project, we linked back to their one of their studies. They found, I think, 267 convictions where informants had then recanted. So I think we are seeing more often that happening. Even in the last, I think, 5 to 8 years, there was a case here with Chad Hines, and I don't know much about his case at all. I'm at the beginning stages of like looking into this. But he's another case that he was exonerated based on DNA, and the informants in his case said, "Oh yeah, we lied."
So I'm curious if there's been much, research into, I mean, certainly when someone, whether you witnessed a crime or made up that witnessed a crime, the reality of someone being put to death, I would think would be a sobering reality for anybody. Is there any understanding or research, as far as you know, into whether people are prone to recant even legitimate testimony because they realize that testimony is now going to be someone's death sentence at imminent way?
Yeah, I'm actually not sure. I haven't seen anything on that specifically, but I do believe that is kind of some of the tension in the Bell case, with his aunt especially, who said, this is my nephew, I love him. Is it possible that these witnesses recanted just to save his life?
Mm-hmm. And that, I guess, we just don't know.
Yeah. How would we know?
Okay, we've got a call from Linda in Mandarin. Good morning, Linda. Go ahead.
Good morning. One of the things that your reporter said earlier regarding there being, is within the law, a limitation on the time that you can present new information once it's discovered. And most of the people who you see exonerated, they're never, and they go through the appeals process. It's normally 30 or 35, 25 years later. So even if they're innocent, they've already, incurred almost a life sentence. And if you have new information and you can die, there should be no time frame. If somebody made an error or there was corruption in the system, there should be no statute of limitations on proving that or attempting to save your life. And that's the thing that is part of the law. And we found out recently that the law has a lot of twists and turns and it doesn't operate the way we think it should. Thanks.
Thanks, Linda. Yeah, and there are a lot of kind of generous exceptions to time limits in death penalty cases because of the severity of the penalty and a lot of duplication built in and opportunities. But there is eventually, there is a time limit.
Yes. Yeah, like I said, anytime you want to file for post-conviction relief, it has to be on new information that couldn't have been discovered before. But you do see in death penalty cases that relief being filed over and over and over and again. Once the governor signs a death warrant, that really speeds up this process because then it's a race against time. And that's been some of Michael Bell's, his attorney's arguments is like, we did not have enough time to develop these witnesses and to develop these recantments.
Or their arguments even.
Exactly. Anything, because they, once it's signed, the Florida Supreme Court issues a scheduling order. So the order was you have to have your first hearing on this day. You have to have any potential evidentiary hearing 1 day later. You have to have, the judge had his response to the evidentiary hearing within 24 hours because the Supreme Court, you said you have to have your response by 11 a.m. this day. And I think it was filed at like 11:30. So the Florida Supreme Court really schedules how this looks, and it's very fast.
And I mean, Michael Bell would be the 8th person executed in Florida this year. And so there have been a number of executions already on that tight timeline. But so you talked about the Florida Supreme Court. I mean, they're involved. They have an opportunity or even an obligation, I guess, at this point to weigh in. Has Bob Norgard, the attorney for Michael Bell, brought an additional motion to the Supreme Court based on this?
Yeah. So when the local judge denied any type of like retrial or resentencing, the Michael Bell's team immediately appealed that to the Florida Supreme Court. The state then gets a chance to respond to that, and then Bell's attorneys get their last chance to respond to that. So a lot of the things in these complaints or in the appeals is very similar to what we saw at the hearing. One new thing and one new argument, at least, Norgard is questioning how the judge could have found Edwards more credible than his investigator, saying that there was information that
Edwards is one of the two men that testified, that had recanted. And the judge said, essentially in the judge's order, he said, this man who testified was more credible than the investigator who brought forth the affidavits.
Right. And this is the man who said that he thought that he was talking to like a movie crew. And so Norgar is arguing that determination, saying, how could our investigator know this information? Like, he did not testify at trial that he was given furloughs by Belina. So how could our investigator,
if it was
feed
made
that?
up, you mean?
Right. If it was made up, how would we have known that? Like, he must have given that to us because it's new information that we've never had before. So that's really kind of the only new thing I've seen in the appeal document so far. I believe right now it is the Florida Supreme Court's turn. So we're just kind of waiting to see if they affirm the local judge's decision and what goes from there. And of course, with death penalty, you could argue it all the way up to the U.S. Supreme Court.
Right. Okay. We've got a question from Mark in St. Augustine. Good morning, Mark. Go ahead.
That stuff about being movie producers, that harkens back to the Olympic bombing case where they had that security guard and he was being interviewed by cops and he knew they were cops, but they said something, what tipped him off about it being sneaky was he said, if you were producing a movie, if you were writing a script, how would you have done it? And that kind of tipped him off and the result. But my question was, what is is the only evidence convicting this guy tainted eyewitness testimony, or, oh, by the way, there was a gun that was found and the bullets matched and it was in his possession or something like that?
That's a very good question, Mark. Richard Jewell was the guy in the bombing in Atlanta.
Yeah, I've never heard of that before.
Yeah.
So great question about the evidence. I'm still, like I said, I just got onto this story. Not even when the warrant was signed, when the post-conviction appeal was signed, and I saw the similarities between Hartley. So I'm still trying to, catch up on exactly what happened. But there was his girlfriend bought a gun right before this happened, and the testimony came out that she gave him the gun that was used. In the original trial, there was also testimony that he openly said, "I want revenge. I want to kill, this person," and that there was a plot to do that. And then his aunt had testified in '95 that she heard him say, "I did it." Her testimony last week changed. She said that he actually said, "We did it." And the distinction there is that opens up a question of if he was actually the shooter or not.
And we should say that Michael Bell, later pleaded guilty to 3 other murders. And, I think that there's a world of people out there that, perhaps feel that, if somebody is wrongfully convicted and that's the only crime that they've been convicted of, that perhaps they have more of an appetite for a reversal on a death penalty case than if somebody has been involved in other crimes that they've confessed to.
Yeah. I actually haven't seen, I know that he had those convictions, but I can't recall seeing that in any of his post-conviction motions from the state as any type of argument. I could be wrong. There's so many documents I've read. But I did wonder if that had any implication, if those other murders had implication on this decision.
Yeah. I mean, I would almost think that prosecutors would be reluctant to bring up anything else, because they really aren't allowed to consider that. I did want to just briefly mention, one of the things that is brought up in these motions is the fact that Michael Bell spent time at the Dozier School for Boys. They're sometimes called the White House Boys because of the terrible abuses that occurred there. It was a state-run facility for sometimes kids who were just runaways or orphans, but some of them also had some criminal offenses. And he was there. Michael Bell says that when he was there, like a lot of the kids, he was sexually assaulted. He was forced to participate in a fight club that sometimes the people who ran the jail, the facility, would make the kids participate in. And so a real abusive environment that he was subject to.
Yeah, and I talked to a local attorney about that, actually, about why that wasn't a mitigating factor. But in 1995, nobody knew what was happening at that school. And she said that would have been something and should have been something that his post-conviction attorneys, years ago brought up as mitigating factors and an argument of getting him off death row. I don't know if that ever happened because, again, like 30 years of documents, I am one person. But that has been in the motions recently. That was not something that was actually argued during the hearing last week. They focused it on the witnesses. But just an interesting point about this, too, is there are 29 other inmates on death row who had spent time at Dozier.
Okay, that's a lot. That's kind of an interesting statistic. Well, Nichole, it's great to talk to you and to catch up on this case. You've done some extraordinary reporting, as you say, a lot of documents, one person. We appreciate that you're taking that on
I'm doing my best.
doing your best. So there's a hearing in the Hartley case tomorrow, and
Yes.
then what are we expecting from the Florida Supreme Court on this Michael Bell case?
I actually don't know. I don't think that the Florida Supreme Court gives themselves a deadline or a schedule. I think it's just when it happens, it happens. But I have my notification set up. I'm refreshing the page, and I know we'll write a story when that decision is made. And yes, Kenneth Hartley has just a status update in his case tomorrow.
All right. Nichole Manna, we'll be watching for the next headline in the Tributary. Thanks for being here.